Hello and welcome to our first live broadcast at the Java User Group in Berlin. We are pretty happy to do something after about 1 year of break from any talks. Actually, Oliver, which I send a lot of greetings from, he unfortunately is on travel. Well, that's not unfortunate, but he's on travel, but he unfortunately forgot his power adapter. So he's probably not able to join us today. We did actually not want to join the whole online community of Java user groups that do a lot of talks, because we thought, okay, the main advantage of our Berlin user group is that we have the meetings afterwards, that we have our small community. And we wanted to wait, but actually now we waited 1 year. And on our last regular meetup, our Stammtisch, Kai proposed to do a talk about the recent lawsuit of Oracle against Google and the final results now after about 10 years or something like that. And we thought, okay, let's do this and let's do live streams now. And we will probably do some more in the near future. But this is our first experiment. Let's see. As far as I can see, we haven't so many visitors at the moment. But just a second. Yeah, okay. So if you have any questions, like in any other live stream, please use the chat, and we will, and without further ado, I will just hand it over to Kai. He will introduce himself, and he will do hopefully a very nice talk. Right.
Yeah, thanks very much. So I'll get right to it. So we'll be talking about that Google versus Oracle lawsuit, and there's going to be a primer on intellectual property rights that you will hopefully find actually kind of amusing. I always do, and so I hope to share my love for this topic. Who am I? I'm Kai Horstmann. I'm the author of the core Java book that had the first edition in 1996, right when Java 1.0 came out, and 11 editions since. I'm right now working on the 12th edition that should appear whenever JDK 17 appears. I've written a bunch of other books, but I've been with Java really from the beginning. And so a lot of the history that I'm going to be talking about today is something that I've really lived and can talk about with some knowledge and passion. I am not an attorney, so whatever you hear in this talk, do not take it as legal advice. If you need legal advice, you know how to find an attorney. But quite frankly, I've dealt with many attorneys in my life, and it is always good to have some basic background about intellectual property rights. And so here you're going to have a case study that is going to teach you a lot about how that works. So what is intellectual property? You all know, I'm sure, that April 26th is Intellectual Property Day, and you celebrate it like every right-thinking person should. Just kidding. So there are 4 categories of intellectual property called trademark, trade secret, copyright, and patents. And we'll be talking about all of them. So intellectual property gives the owner of it legal entitlements that can be, as you'll soon see, very powerful and very lucrative. Conversely, if you step on someone else's intellectual property, it can be very expensive. So all intellectual property rights are a contract between society at large and the creator of intellectual achievements. Those contracts are not something that is God-given. It is something that society has worked on for centuries. And so those are not absolute rights, but they are rights that have developed through some feeling of what is beneficial to society and what is fair play. Let's start with trademarks. A, they are simple to understand, and B, they are central to our story of Oracle versus Google. A trademark is a distinctive sign that marks a product or service. What you see on the right is one of the first trademarks of an American company, the Smith Brothers, as you can see, or as they are known in the trademark community, when you look at the logo here, as the brothers trade and mark. A trademark must be registered to be protected. If you have a trademark, you register it with the trademark office of your country and of other countries, and then you can have it as a registered trademark with that distinctive R with a circle. But not every thing that people like to use as a trademark can be so registered. For example, Microsoft Windows is not a registered trademark. Microsoft certainly tried, but the trademark office in the United States said Windows was not sufficiently distinctive, that there were before other windowing operating systems such as X Windows, and so Windows by itself was not distinctive enough to earn a trademark. Somehow Microsoft managed to live with that fact. There's always a TM next to Windows, and Microsoft does go out and sue companies that use Windows in a way that they don't like, and they're a big enough bully that they can do that. A trademark must be used. So if Microsoft were to stop marketing Windows, then, well, it's not even a registered trademark, but say if the Smith brothers no longer market their cough drops, then others can use the trademark. A trademark must not become generic, like aspirin is in the United States, or Googling. It's very dangerous for Google. If everyone says Googling instead of searching, then the trademark can get lost. And of course, Google knows that. And whenever they find anyone anywhere writing about Googling when they mean an internet search, then they try to write a letter. Now, in software, we have trademarks. And even open source software needs to enforce their marks. So, for example, Mozilla or Ubuntu have trademark guides. We can here see that Mozilla says it's very important that we strictly enforce our trademarks and so on. It is important because if you don't enforce them, you can lose them. And in the world of open source software, there has been some excitement about this, that sometimes someone doesn't like the Mozilla trademark guidelines. And there was a time actually where some Linux distributions wanted to distribute Firefox. They didn't like the trademark guidelines. There was something about some logo that they felt was not free enough. And then they changed the logo and they changed the name of the product to Ice Weasel, or later on an Ice Cat. So this can be done, and that way one can overcome those trademark issues. Now, for us, we care, of course, about the Java trademark. So Java is trademarked by Oracle. If you want to use Java in any way in your product, you need a license from Oracle. That's why good old Java EE, when it was given over to the Eclipse Foundation, is now called Jakarta EE, because Oracle was unwilling to give the trademark for the use of Java EE with the code that they now abandoned. So that means that Eclipse had to come up with a new name, and painfully for everyone who still uses Java EE, now all of the packages will have to be renamed. So the existing packages that are there can be called Java EE as long as you make no changes to it. Long term, that's not tenable. So there's now this painful process of renaming for trademark reasons. Another thing is, you may have seen that there is a nifty site called Adopt Open JDK, where you can download the JDK without being encumbered by onerous restrictions from Oracle. While it has JDK in its name, Oracle is objecting to that because JDK is also a trademark that they have. And so it's now being renamed as Eclipse Adoptium without the JDK. That rebranding is currently in process. So Oracle is being nice about this, but they insist that they do not want to have their trademarks tainted in any way. Again, we'll see where the Java trademark is important in our Google versus Oracle epic conflict. The next intellectual property protection is trade secret. A trade secret is pretty simple. It's some kind of a secret that is known to the creator of a technology or something. Like here, I have the Coca-Cola bottle because, of course, Coca-Cola has a trade secret on whatever mix of ingredients they use to produce that fine substance. And it's protected by confidentiality. confidentiality. So whoever is the chief chemist at Coca-Cola surely had to sign some agreement that he will never tell or see what that stuff is actually made of. Unlike other intellectual property rights, a trade secret can extend indefinitely. As long as it's secret, it can be a trade secret. On the other hand, if it's no longer a secret, the protection is simply gone. If that chief chemist at Coca-Cola were to just blurt out the secret formula for that fine drink, there's nothing Coca-Cola could do about it other than, of course, sue the chemist for damages, because once it's not a secret, it's no longer a trade secret. There's also, and that's going to be important in our story, there's no protection against independent discovery. If someone managed to reverse engineer Coca-Cola and find out exactly what's in it and produce something that tastes 100% exactly the same, no one could stop them from it. So it is perfectly legal to reverse engineer. Again, something that we'll be talking about more. There's only one exception. In the United States, there is a version of the copyright law called the Digital Centennial. I don't remember what it stands for anymore, but it has an interesting provision that says that it's no longer legal under copyright to publish the results of reverse engineering that would enable someone to make illegal copies of some copyrighted good. So there was a big huff about that about 20 years ago when someone published the code that is used by DVD players to decode a DVD stream, and they were sued and enjoined from doing so. If you get a copy of the slides, go ahead and click on this link. There are some amusing scenarios there by a professor by a law professor who says, well, that's kind of weird. How can you be enjoined from speaking something that you know? What about singing the code? What about having a haiku or a dramatic performance of the code? And are those things legal or not? Right now, nobody knows, but it's peripheral to our story, so I will not dwell on it, even though it's a lot of fun to read about. Now we move on to patents. So a patent is an exclusive right to an inventor in exchange for the disclosure of the invention. So this is the exact opposite of trade secret. Now, for a patent, the invention has to be fully explained. But then the one who has done the invention has the monopoly right for it right now for 20 years from the filing date. There are 3 requirements for a patent. It has to be novel, obviously. It has to be non-obvious to one of ordinary skill in the art. Now, what that means is not so clear, because there have been many patents where you and I as programmers would say, well, that's pretty obvious, but still it was held that it was non-obvious, because if it had been obvious, why didn't someone do it before? And the third thing, it has to be useful. If all of these 3 things are deemed to be true by a patent examiner, then a patent is granted. Fun fact about patents, from 1719 to 1880, anyone who wanted to file a patent had to give the patent office not just a written disclosure of the invention, but also a model. On the right here, you see a model just like that, and I'll tell you in a minute what that model is about. The reason for the model requirement was that the examiners in the patent office had a large number of applications for perpetual motion machines. As soon as they required that models should be supplied as well, those patent applications stopped. Historically, computer software was not deemed to be patentable. Just in general, patents can be about processes, machines, article of manufacture, and compositions of matter. That's what the American law says. And scientific truths or mathematical expressions are expressly not patentable. And it was held for many years that computer software is kind of like mathematics written down in code. And so it was clearly not patentable. That changed in 1983 with the RSA crypto system. So the inventors of the RSA crypto system had the bright idea of writing up a patent that danced around all of the mathematics and instead said, well, we're patenting this machine, and because a machine is patentable, and the machine does this, and the machine does that. And somehow the patent examiner thought that was fine and granted the patent. And it opened the floodgates to a very large stream of software patents. At first, they all played the same game. Eventually, the patent office decided that that was no longer necessary, and anything in software now is perfectly patentable. So let me give you a couple of examples of patents, again, because some of them will be important in our story. You saw on the previous slide that boat-like device, or whatever it is, and that was a patent, I believe the only patent that was ever given to an American president, Abraham Lincoln, and he patented a device to lift boats over shoals. What you see on the right is a drawing from a patent by Edison called electric lamp. Now, no one would deny Edison the validity of his patent, right? He had spent countless hours in figuring out how to make an electric lamp. He had tried 10,000 materials until he finally hit upon one that worked for the filament, which actually was charred bamboo. Here we have a patent for, and again, if you have get the slides, you can click on those and look at them, for the RSA patent. Here's another interesting patent, the so-called XOR patent that was infamous some time ago. It was one of those things that is so simple that you wonder how could they have gotten a patent on it. What it is that if you want to put a cursor on a graphical screen, then you XOR a black box on it, and all the black pixels turn white and all the white pixels turn black. And then if you want the cursor to go away again, then you do it again. That was the claim that the patent holder actually tried to assert with some success against some companies to squeeze out some royalties. Similarly, for a while, Unisys held a patent that made them collect royalties on GIF files, which is why we now have PNGs. Those patents have now expired. Remember, patents are 20 years, so we no longer have to worry about them. So here I say it's a typical junk patent, and I just want to just show this one here. This is by a certain Horstmann, that would be me. I was working for a company, and we patented like everything in sight that we could. This was, when you read through this, you'll see that there really is nothing to it. It's a very straightforward process. And so I wrote a bunch of them, and just about everyone in the industry knows someone who did this. There's one that's kind of not unlike that one. I'll show you again just how it starts. This is by a certain Gosling, about a method and apparatus for resolving data references in generated code. And when you read through it, you say, yeah. And there's like nothing in it where you say, this is nothing like the light bulb. But it will play an important part in our story of Google versus Oracle. So, as a slight aside, how ridiculous patents can get, Apple and Samsung sued each other, and Apple at one point sued Samsung for rounded corners. So Apple said, we have a design patent that specifies how a mobile device could look like, and it looked, the drawing in the patent looks like what you can see on the right. And yeah, rounded corners. And Samsung apparently had a device with rounded corners. And in August 2012, a jury of 12 citizens in Northern California said, yeah, that's just so. Apple has a legal monopoly on round corners. And Apple was awarded $1.05 billion in damages that Samsung did have to pay. There was, they tried to appeal and it got nowhere. These are not very common. And it's an aside to our story because the patent that we talk about is just a regular software patent. Now, finally, copyright. That's central to what I want to talk about. So copyright protects, unlike a patent protects an idea. Copyright does not protect the idea itself, but the expression of an idea in writing or in song or in film or whatever. In the United States and now in many countries in the world, you don't even have to apply for a copyright, unlike a patent where you have to file. or a trademark that you have to register. The law says that once the expression of the idea has been created by you through mental labor, whatever that may be, and fixed in a tangible medium such as paper or celluloid or whatever is a tangible medium in these digital days, then you automatically have a copyright. Copyrights last a very long time, for the life of the author plus 70 years, or if it was work for hire, for 120 years from the date of creation. So the copyright for any program that was written today for a company is like really pretty long. There are fair use exemptions that we'll look at in a minute. So there are situations where even though something is copyrighted, you are allowed to use it nevertheless without getting a license. A bit about the history of copyrights. It's actually quite an old thing. So in 1710, in Great Britain, there was something called the Statute of Anne that started it. And the United States, in the Constitution, have a clause on copyright. The Copyright Act of 1790 codifies pretty much what the Statute of Anne said, that a copyright shall be for 14 years. And after the 14 years, if you so desire, you can file for a renewal, and then you get another 14 years. That's how it was when the founding fathers put copyrights into the Constitution. So in fact, that's what Article 1, Section 8, Clause 8 of the US Constitution says: to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So here one can very clearly see why these intellectual property rights are a contract. Society at large says, we want to promote the progress of science and useful arts. And therefore we make a deal to those who create it, namely that they can have an exclusive, a monopoly right to their creations for a limited time. How limited? In 1831, it was deemed to add another 14 years to it, so now it was 28 years and 14 years renewal. In 1909, the renewal was also extended for symmetry to 28 years. In 1970, it became the life and the author plus 50 years in the United States, and that was to unify it with what was going on elsewhere in the world, where that was kind of a common arrangement. In 1998, there was an emergency that caused a certain corporation to lobby Congressman Sonny Bono to sponsor the Sonny Bono Copyright Term Extension Act. Sonny Bono was an actor, and he was in a previous life, and he was in Congress. And so he said, well, we've got to add another 20 years to this period. And there was an important reason for that, because if that had not been done, Mickey Mouse would have been copyright free in 1999 or some such thing. And anyone could have taken Mickey Mouse and used it for whatever nefarious purposes. That, of course, had to be prevented. People sued, but the Supreme Court upheld the law, saying, somewhat to everyone's surprise, because at the time the Supreme Court very much wanted to find out what was the original extent, or the original intent of the founders of the Constitution. The founders of the Constitution clearly thought of copyright as something that was pretty short, clearly within the lifetime of the author. But the Supreme Court said, it's okay, life of the author plus 70 years. It's still a limited time. I guess 10,000 years would have been a limited time, and it was upheld. So there we have the copyright. So now let's move further to some computer cases here. What you see on the right here is a compact computer. I actually had one of those things. So 1981, as many of you may or may not remember, IBM released the IBM PC, first desktop personal computer, and IBM published the spec for the bus and the source code for the BIOS. They knew this was not the greatest computer, and they knew they needed the help of the community to make it better, and they wanted to make it easy for third parties to produce hardware components and to produce software. So Compaq wanted to make a clone, and they realized that they had a problem with the published source code for the BIOS. Clearly, it was not a trade secret. It was published, but it was copyrighted. And they knew that they were tainted as soon as they read it, because if they had then written it somewhat differently, IBM would argue that they saw the original, they just made small changes to it. It was a copy. And so they came up with an elaborate scheme where they had two engineering teams, what they called the clean and the dirty team. The dirty team did read the BIOS source, and then they told the system call API that was in the source to the clean team, which had never seen it. They certified under penalty of perjury that they had never, ever read the source code. The clean team then implemented the calls, and the dirty team tested them and gave the clean team some hints and say, hey, this is not working, that isn't working. And as a result, IBM never sued Compaq. There were other companies that didn't go through that kind of precautions, and IBM sued them, but they never did sue Compaq. And so there was a very clear understanding that it is okay to reverse engineer. It is just not okay to directly copy. So the next case that gives us some important background is Lotus versus Borland. So Lotus was a spreadsheet that innovated the concept of macros. So that was their key thing. The way they did the macros is that you recorded your keystrokes as you moved through the menu hierarchy. So I still remember that you typed a slash that got you in the menu, and then you would type like a W for this option and whatever. And that was your program, that was your macro, the sequence of keystrokes. So when the Borland company came up with a competing spreadsheet, they felt it important that they needed to copy the menu structure because people had spent thousands of hours coming up with these 1, 2, 3 macros, and Borland felt that no one was going to move to Quattro if they couldn't migrate their macros. Lotus sued. The district court agreed that the menu structure was eminently an intellectual creation, and it was therefore protected by copyright simply by making it. And after all, it was not something that was so rigid that there was only one solution. You could have said quit instead of exit, or exit instead of quit, or whatever. So the appeals court, on the other hand, took the opposite point of view and said that the menu structure is not so creative that it was worthy of protection. It's a method of operation. That's a concept that existed in copyright for quite some time. In 1879, there was a lawsuit by someone who invented some accounting system, published a book about it, sold forms that could be used to do that accounting. And then another author published a different set of forms, not the exact same ones, not a complete ripoff, but another set of forms that also could be used for the accounting system. And he prevailed in court because the court said this the accounting system is not worthy of copyright. It's just a method of operation. So in Lotus versus Borland, it was held that a menu structure like this is not copyrightable. The court pointed out that it would be an absurd burden for users if they had to learn a new menu structure just for the heck of it. Moving closer to our target, when Sun Microsystems first came out with Java, Microsoft took out a license in 1996, right when Java 1.0 came out. Microsoft saw the writing on the wall, and so they went straight and said, yeah, we'll take out a license. The license agreement required a couple of things. Sun was worried about Microsoft. So Sun wanted to make sure that Microsoft wasn't going to mess with it. And so they required in the license agreement that whatever Microsoft comes out conforms to certain test suites. And when Java gains new features, that Microsoft would implement them within 6 months. Microsoft did nothing like that. They practiced what they did at the time, their strategy of embrace, extend, and extinguish. So they added new features that were not part of standard Java. There was a thing called delegates. They had direct calls to the Windows API, and they refused to implement other features. The Java native interface was never implemented, and nowadays this doesn't sound like great shakes, but at the time RMI was considered something valuable, and Microsoft didn't do it. So Sun sues Microsoft. And now what do they sue for? They don't sue for patent infringement or copyright infringement. They sue for two things: breach of contract, because Microsoft didn't do what the contract required them, and the illegal use of the trademarked logo. So the contract says you can use the logo if you follow these things. Microsoft used the logo, they didn't follow the contract. And this dragged on for 4 long years, and eventually it becomes clear that Microsoft can't win, but they apparently are not in such a terrible position either, because all they have to pay is 20 million. And they discontinue the product that I'm sure you've always wanted to use, J++. If anyone remembers what J++ was, it was that version of, that bastardized version of Java. All right. Now, Android. Android was founded in 2003, bought by Google in 2005, and the first actual phone that used Android was released in 2008. It's that handsome thing that you see here on the right that still had a keyboard. I had one of those. It was a terrible phone. It was programmed in Java. Why Java? Because people are familiar with Java, and so the Android folks felt that was better than making them learn a new language. And so it used the Java API, the Java SE API. At the time, there was a Java ME for the micro edition for portable devices, and it didn't use that, and we'll see in a minute why. It did not use the JVM, but a different virtual machine. Of course, it didn't make sense to use all of Java SE in a phone, like Corba or RMI or Java Beans, or there's a lot of things, Swing, this thing didn't run Swing. So they only used those parts of the Java API that they felt was useful for the phone. But still, they used the API as it was familiar to programmer. They looked at whether they could just take out a license for Java ME, the micro edition, but it was really a poor match for what they were trying to do. ME was there for feature phones, not for smartphones. It was very limited, and so they just didn't want to go that way. Well, Sun did offer a licensing deal, rumored at 30 to 50 million, and they just could not come to grips with how this would work, because Sun said, well, it has to be Java SE or ME, and neither of those really worked. And so Google then said, well, the heck with it. There was at the time a clean room implementation of large parts of Java SE. They picked those parts that they wanted as the implementation, kept the standard API, not the Java logo. They didn't want to have anything to do with it. They learned their lessons from Microsoft. And Sun was aggrieved by this. They felt that this was not right, but they didn't really see what they could do. They were falling on hard times at the time. Google was a big company. They also felt that anyone using Java is better than someone not using Java, so they let it slide. In 2009, Sun has fallen on really hard times, and Oracle buys out their assets. So now we finally come to the main part of our story, the lawsuit. So in 2010, Oracle, that just has paid a pretty penny for Sun's assets and didn't have much to show for it, because remember what Sun had at the time. They had a line of hardware that was rapidly falling out of favor. They had Java. Then they had a few minor things like OpenOffice. I think it was called Star Office at the time, and MySQL and VirtualBox and stuff like that. Oracle kind of sidelined those. With Java, of course, they said, oh, we have the rights to Java. Someone is clearly abusing this, namely Google, and so they sued. They sued for 2 things. They said, Google is using Java, it's implementing Java, it is violating some of the patents. So they came up with a list of 20-odd patents, and the circuit judge said, there's no way that a jury of 12 people from Northern California can understand 22 patents. Give us your 2 best shots. Those 2 best shots were the one that you just saw, the method and system for performing, no, sorry, that was the second one, the method and apparatus for resolving data references. And then they had another one for static initialization. Those are very technical things. And as it happened, the Dalvik virtual machine worked differently enough from the Java virtual machine that the jury said that Android does not infringe on those patents. It's not clear how 12 people from all walks of life can make these technical determinations, but that's what the American jury system is like. The second part is copyright. So there are the APIs, and that's the bigger part of the story that I'll get to soon. And then there were some minor sideshows. It turns out that Josh Block, the very same Josh Block from Effective Java, when he had worked at Sun, had written some code for doing some range check, 9 lines of it. And then when he worked at when he worked at Google, he copied those same 9 lines of code, and they're now somewhere in Android. A lot was made out of those 9 lines of code, but of course it wasn't very much. Then there was a very confusing situation where someone said that there were 8 files that were completely identical except for nefarious renaming. It later turned out that those were just decompiled, and they looked similar because the decompiler from the bytecode did something slightly different. And they were only used in unit tests, and they were never part of Android. And so they didn't really amount to a hill of beans. So for those 2 things, for Josh Block's 9 lines of code and those decompiled test files, it was later decided by the jury, said, yeah, that was copyright infringement, and the parties settled for $0 of damages because it was just not very much. So let's look at those APIs. There were 37 APIs, and here they are, that Android uses from Java SE. And so it's some mix of things that are obviously useful. Java util logging, you could debate whether that's useful or not. But regex and JavaNet, all of that stuff, that there's Java I/O here, all of that every Java programmer kind of knows by heart. And so it would be a real pain if you had to re-implement those. They are actually still to this day published in the Android SDK. If you just look at the names of the classes and the method signatures, the ones that declare the method, that amounts to about 11,000 lines of code. I was surprised that 37 APIs have that many lines of code, but I looked into it, and some of these APIs are pretty long. So there's about 11,000 lines of code that declare the classes, the interfaces, the methods, no implementation whatsoever. The Java doc was actually reworded. If you look at the original Java doc and the Android Java doc, they're just different enough, just like a high school student would reword something from Wikipedia, but they were not deemed to be infringing. All the source code was this Harmony implementation. That turned out to be about 2.86 million lines of code. So, in 2012, the circuit judge, who we see on the right, Judge Alsop, who actually taught himself to program enough so that he could understand what this lawsuit was all about, he understood what an API was. And he said, it really doesn't matter that the declarations or the method header lines are identical. What matters is the implementation of the method, and no one argued that Google did not infringe on that. Now, in 2014, after Oracle lost and appealed, the appeals court said, no. The API is something that is worthy of copyright protection. It's an intellectual effort. It clearly has some kind of organization. And there is a legal construct of structure, sequence, and organization. And they said that the API fulfilled that, even though it was brought to their attention that the API is really no different from the menu structure that you might have in Lotus 1, 2, 3. They did not see the symmetry with that, and that was their decision. So it was sent back to the district court in a second trial. This time, the jury said, okay, fine, it's copyrightable, but it's fair use. We'll come to a minute of what fair use is. Then the appeals court, the same appeals court said, well, the jury clearly had no clue what they were talking about. It couldn't possibly have been fair use because fair use means this and that. We'll talk about in a minute what it means. And in 2021, just now, the Supreme Court said the appeals court had no clue what they were talking about. It obviously is fair use. Except for a small minority who said it was completely unfair. So what's fair use? So fair use is a part of the Copyright Act and it's in the United States, but international copyright law in other countries has similar concepts. And it says you can use copyrighted materials without a license under some circumstances. To decide whether fair use is applicable, there are 4 factors. The first one is it commercial or nonprofit? And most importantly, is it transformative? Does it use the copyrighted material in a new way instead of simply as a replacement for the original? So as an example, a satire, like you see the Starbucks logo here on the right, and Starbucks can't take me to court, even though clearly that logo has been copied pretty well because it's now transformed into something different, into criticism or art or something. The second one is the nature of the copyrighted work. If it's something imaginative like Harry Potter, then it's less likely that you can use it as fair use. If it's pretty factual, fair use is more likely to grip. The amount and substantiality of the portion used makes sense. If you only copy a little bit, then that's often considered plain and simple fair use. And the effect of the use upon the potential market. So like here, when I reproduce this satirical Starbucks logo, I'm not going to bring the Starbucks empire down to its knees. People will not stop buying coffee. And so that's probably fine. If, on the other hand, I were to make another set of coffee shops using a very similar logo and confuse the market, then that would be a problem. So that's fair use. So transformative is considered an important thing. That means you make it somehow so that it doesn't simply replace the original. And the classic example for that is, if you get the slides, click on this link here, and you're going to see a parody of the song Pretty Woman. Roy Orbison sued, lost in court. All right. So at the Supreme Court, the majority opinion, authored by Breyer, said, well, first of all, we don't want to actually decide the hard question here, namely whether in general APIs are copyrightable. Maybe they are, maybe they aren't. But even if they are, in this case, he feels, and the people who voted with him, it was entirely and totally fair use. Because what Google did was transformative. They took what worked on the desktop and moved it to a new market, namely smartphones. They said the nature of the work it wasn't Harry Potter or Disney, it was organizational kind of drudgery. So fair use grips very well. The amount copied was tiny, less than 1%. And the effect of the market, well, Sun didn't make a dime on mobile Java at the time. And if it hadn't been for Google, maybe the entire market would have been taken up by Apple. And so there's not a claim that Oracle lost a lot of money because of this. And also, if Oracle had been able to hold on to their monopoly, then that wouldn't have been so great because the creative impulses of others would then be thwarted. The minority, authored by Thomas, thought this was completely wrong. They said it was ridiculous that the majority didn't want to tackle the question whether an API is copyrighted. They said there was a lot of code copied, 11,500 lines. That's a lot of copying. Google made a lot of money, undeniably. They said this wasn't transformative. This is not criticism or comment or satire or reporting or whatever. This is just taking the technology and ripping it off. And they didn't buy the economic argument. They said, well, Oracle might have made a lot of money. There was actually a lot of talk about this during the trial. So the Google made hay out of the fact that Sun at the time had a miserable time trying to market Java SE on phones. So there was one phone that actually implemented Java SE, the thing on the right, by Savage, and it never sold. So, but anyway, the minority said, well, maybe it was just too early, and Oracle might have made billions later, and now they were deprived from that opportunity. So, a few days later, I ran into something that seems to have nothing to do with any of this. There was another copyright case where Andy Warhol had created some images of a musician, formerly known as Prince, using a photograph by some photographer. And the photographer later sued his estate and saying, "Oh, that was my photograph, and he took it and used it, and I should be getting compensated for it." She won. And the Warhol estate is now appealing and said, "Wait a minute, isn't this kind of like those rap musicians who took another piece of art and transformed it?" And talking of transformation, remember Google LLC versus Oracle America, all of 2 weeks old? And so they said, well, if Google can copy software line by line, and that's transformative, that's what they put in their brief. So when Warhol copies something and makes it quite different by silk screening, then that should clearly be more transformative. So you can already see Google versus Oracle enter the legal landscape in ways that surely the Supreme Court never intended it to. So what do we learn from this? Well, we can ask ourselves, is it fair that APIs are not copyrightable? And, well, it takes a lot of work to develop a good API, but that's not how copyright law works. Not everything that's hard gives you a monopoly right. Some things do and some things don't. And with developing an API, maybe it's just not something where the way things are now in 2021, where you can have a monopoly. And after all, this is something that I think many programmers agree with, that if you take some existing API and re-implement it, that's probably okay. For example, there's a company that should remain unnamed, it was Oracle, that copied the Amazon S3 API, hook, line, and sinker. And they didn't think that was bad. Another thing that's interesting is, do the courts actually understand this highly technical stuff? When you look at the court record, there was a lot of talk about math.max. And I said, why are they always talking about math.max? And then it occurred to me that of the 10,000 or so API calls, that was the ones that the lawyers figured the judges might actually be able to understand. It didn't work, because then those judges said, well, what's the big deal? If you rename max to larger, people can still work with it, right? And so the point that having an API of 10,000 calls, that's not something that a programmer can simply remember 10,000 alternatives. That point has often gotten lost. So that difference between an API and the implementing code was not at all clear to everyone in the proceedings, except Judge Alsop, who taught himself to code. He did understand that pretty well. The other thing is that we're used to certainty, to determinism, to the right or wrong answer in many of the things that we do. And the law doesn't seem to work like that. The inputs, the rules are the same, but they can lead intelligent people to come to complete and opposite conclusions. Look at the majority and the minority opinion here. They're completely different. And it's just by sheer luck or bad luck, depending on how you feel about APIs, that how the majority has now shaken itself out in the point that now APIs are probably fair game. All right, that's what I have. I hope that it's somewhat amusing and interesting, and that it gives us something to think about. So now, if there are questions, it'd be a good time to do that.
Yeah, thank you. Thanks a lot for the talk. I found it very interesting, especially to see all the base information and what all those things are based upon. One question that came to my mind is, did Oracle at any time try to do this lawsuit in other countries than the US?
No, they never did, and it's that's actually something that people always worry about if these copyrights and patent rights, if they differ too much in different countries, because it would be a complete mess. So that there's generally the feeling that there is a lot of uniformity, and so they felt that if they'd win in the US first, and then they could maybe move on. Right now there's just a few situations in copyright, particularly where the European copyright is a little different. You can see that when you go to the Project Gutenberg, where they give books whose copyright has expired. In Germany, you can't see it. Mm-hmm. But that's kind of an unusual situation. Generally, copyright is pretty uniform.
Yeah, But that's a little bit surprising. I always thought this is, or the reason for that is that in the US, the copyright period is a little bit shorter than in Europe. But I think it's 70 years in Germany too, 70 years after the death of the author, or it's 75. I'm not sure about that.
Yeah, I think there may be a small difference, but they've worked on it over the last couple of decades to try to iron out differences.
Yeah, there are, as far as I know, there are two big differences, at least between the US and Germany. One of them is that you can't actually transfer copyright in Germany. So the original author has always the copyright. You can just transfer the rights to use this. And the other one is, as far as I know, patents or software patents can still not be granted in Germany or in Europe. Because we still have this situation where we say, okay, software is something which cannot be patented. But I'm not sure about that one. Actually, it might have changed in the last 10 years or something.
Yeah, that would be nice. And I think, again, you see some convergence because in the United States, there was an excess of those patents. And that has now been somewhat reined in. There were a couple of decisions that says these processes cannot be patented. And then some laws were passed that. So I think the software patents are not the Wild West that they were 20 years ago.
Mm-hmm. And by the way, talking about patents, you mentioned that the Oracle lawyers picked two of the patents and tried them at court. What about the other ones? Did they ever try to?
They lost the chance. So that the circuit judge said, you can't assume that 12 jurors can go through 24 patents.
Okay.
They said, give us your best shot.
Okay, I see.
And that's within the right of what a judge can do. It's also interesting that can happen to you, but that's how it went. And Oracle never felt that they could do anything about it.
Okay, cool. So, chat, is there any other questions? I will just ask you also visually. Björn, by the way, wrote that in Germany there is a difference between Urheberrecht and Verwertungsrecht. What I was exactly, or what I was talking about too. Yeah. And Werner, by the way, mentioned that it's a very, it's kind of ironic that the S3 API example you gave, because James Gosling is now working at Amazon.
Okay.
So, okay. Good. Yeah. So I don't see any other questions. So thanks a lot. Again, what I said during our small break we had, we will just cut out the network problems, so that shouldn't be an issue. And then we will put on the talk on record on our channel. We plan to do more talks in the future. So please subscribe. We plan to do that and subscribe to our channel. Then, yeah, I know that everybody YouTuber says that, but it's important on YouTube. And we hope to have some more pretty exciting talks for you in the future. Even if we will have live sessions again, we probably try to record more of them than we did in the past. Thanks a lot. And yeah, have a nice evening.
Okay, well, thanks for coming, and I hope you enjoyed the talk.